Today was day 21 in Karen Read's retrial, and there was one very important witness on the stand for the entire day. And in fact, he is not quite done on the stand. His testimony is going to continue tomorrow, finishing up direct examination and then moving on to cross-examination, which is going to be performed by Robert Alessi. And by the way, tomorrow, trial is starting at 10 a.m., so you should definitely join us right back here at Brother Counsel Studios for the live stream beginning at 10 a.m. tomorrow. Now, Dr. Welcher's job for the Commonwealth, a very important job, is to explain to the jury how the damage to Karen Read's Lexus and the injuries suffered by John O'Keefe are consistent with one another. After all, we know from trial 1.0 that this was one of the big problems the Commonwealth had, that they had these ARC experts who largely went uncontradicted in their opinions and in their reconstruction, and their opinions were that the damage to the vehicle and the injuries suffered by John O'Keefe are not consistent with one another. So the Commonwealth went and hired their own accident reconstructionist, Dr. Welcher, to explain to the jury how, indeed, the damage to the vehicle and the injuries suffered by John O'Keefe are consistent with one another. Now, before we jump into the substance of his testimony, first, there was a little voir dire that happened with Dr. Welcher out of the presence of the jury. And that is because we know that Shannon Burgess already testified, and Shannon Burgess also works for Aperture and worked together with Dr. Welcher in creating this reconstruction. His job was more to look at the infotainment data and the modules and the Lexus data and the phone data and talk about the variants, and he amended his report in the middle of trial. And because of this amendment, Dr. Welcher also had to amend the timeline in his report. So obviously the defense was not so excited about this. They were not so happy about it. So Judge Cannoni did allow them to have some voir dire of Dr. Welcher on this specific point. So Dr. Welcher was grilled by Robert Alessi for a little bit, and eventually, this came out that there were some changes because of Shannon Burgess's report. Now, another issue came up during this voir dire, and that is that you'll recall from Shannon Burgess' testimony that he was attacked on his credibility because Aperture listed him as having a bachelor's, and on the CV, which was linked in the Aperture website, it also listed him as having a bachelor's. And in fact, that bachelor's, a BGS, a bachelor's in general science, actually does not exist, and the University of Alabama does actually not give that type of bachelor's. So Shannon Burgess was attacked, and we all remember that. Well, the question now is, did Dr. Welcher hear about what happened to Shannon Burgess on the stand? After all, we know that there's a sequestration order, and Dr. Welcher cannot find out about anything that happens in trial. So the defense wanted to find out about this as well. So listen to what happened about whether Dr. Welcher found out about what happened with Shannon Burgess on the stand.
Now my next questions go to Mr. Burgess. Mr. Burgess is a colleague of yours at Aperture, correct?
Correct.
Are you aware of issues relating to the accuracy or inaccuracy of his CV?
Unfortunately, I've been bombarded with emails that have referenced that. I've seen it. I have not read them.
You've been bombarded with them, but you have, and you say unfortunately, but you have not read any of them? None?
Maybe one or two lines. For example, they come in, they're looking like legitimate business emails. And then I pull it up as a business email. I'm like, okay, I'm not supposed to do this. Court said I can't look at this.
So he does know something about what happened with Shannon Burgess and Aperture. So he is familiar, and therefore he can somewhat be prepared for that line of cross-examination. And that really takes a lot of the wind out of the sails for that cross-examination. But he claims that he did not read the emails. He just kind of looked at them for a little bit, and then he realized, I cannot be reading this. And he quickly exited out of that email. So that is what we found out in the beginning of trial today before the jury was called in. Okay. Then we had Dr. Welcher, and he went on direct examination, and we found out about his background. He actually does have a master's. He does have a PhD in biomedical engineering, not to be confused with biomechanical engineering. Biomechanical is like a subset of biomedical engineering, okay? And he's published a lot. In fact, he has a specific article or paper on side swipe collisions, which is very relevant to this case. So he worked at Aperture, and he actually works in the California office with 5 other people on his team, and he mostly works with that team without anybody else involved. Now, they went through all the materials that he reviewed, the police reports, the cars report, the ring videos, the dash cam videos, the photos, and videos of the vehicle and the scene. He definitely reviewed a lot of materials before doing his accident reconstruction. He examined also witness statements. He examined witness testimony, the Lexus data, the medical examiner report, the Jennifer McCabe's phone data, also the Boston magazine interview with Karen Read, the Dateline interview, the 2020 interview, also some lab reports from Bode, crime scene response reports, UC Davis, that report, the Verizon, the GPS records. Okay, he reviewed a lot. And then he got into the next question, which I knew was going to come out because this is something that we were hearing a lot about, how the ARCA experts did not inspect the actual Lexus. And this was the argument that we hear a lot of times, that that's the reason why ARCA should not be trusted, and they lose credibility because they did not actually look at the Lexus. And even though the ARCA experts testified it wasn't necessary, but we knew that Hank Brennan was going to bring this point out. So he did just that with Dr. Welcher. So let's take a look at that. Give me 1 second. All right, here we go.
So that's me. Oh, that's my first slide.
I have a couple questions for you, Dr. Welcher.
Please.
The first is, your office is in California.
Oh, yes, sir.
Why was it important to come all the way out here and view the scene firsthand?
And you want to have as much information as possible. So I wanted to, physically look at all the things so I can actually see with my own hands, my own eyes, lay hands upon it, look at it as best I can. You try and inspect and look at as many things as you possibly can. Sometimes they don't exist anymore. Sometimes they're gone. And you have to make a best approximation if you can't do that. In this case, I was able to look at the scene in both vehicles.
Was that an important part of your study, doctor?
I think so. Again, it's always good if you're going to talk about what happened to the cars or what happened to the people, to look at what happened to the cars, meaning to actually look at the cars, not just look at photographs when possible. So I have physically looked at the cars. For example, on the Lexus, I climbed in it, over it, underneath it. I downloaded data from it. I did a whole bunch of things looking at Ms. Reed's Lexus to assist in my analysis, to try and add some further objective data to what we're doing here. So same thing with Mr. O'Keefe's vehicle. Looked at the rear bumper, took some pieces off the rear bumper to see what was behind the cover, to see what kind of damage we did or didn't have. So went to the scene, looked at the measurements of the curb, looked at where some of the lines are on the road, because you can see them in some of the photographs. Again, it's always good when possible to inspect everything you can inspect.
So there you go. And the reason why, obviously, that was all brought out is so that the Hank Brennan can make the argument that our expert is better than the ARCA experts. After all, he actually went to the scene. Even though he lives in California, he went all the way to Massachusetts to inspect the scene, inspect the vehicle, inspect John O'Keefe's vehicle, and take some samples, whatever needed to do to it. And that's why they brought that point out. So then he moved on to some other things that he did in terms of downloading the black box, the EDR. Okay. Then he got into a very interesting point. Okay. This is the first most important point, one of the more important points that he had to bring out from this witness. So they're talking about the mileage on the odometer. Okay, the mileage on the odometer is actually very important in this case because, if it accounts for all the traveling that Karen Read did in the Lexus, so then there can be no questions of other people trying to manipulate this vehicle and driving it backwards, maybe in the police station, maybe Proctor took it backwards and tried to manipulate it that way. So they want to show that the odometer accounts for all the travel that they've done in this case, that Karen Read did in this case. So take a look at this part and remember that there was one question about how long it's going to take for Karen Read to drive from 34 Fairview back to One Meadows. After all, we know that she connected her phone connected to the Wi-Fi at One Meadows at 12:36. And if the collision happened at 12:32, that means that she would have to drive there in 4 minutes, right? And people have been saying, well, it takes 6 or 7 minutes at least, maybe even 8 minutes to drive there. So listen to what comes out in the testimony here.
So you can see that's looking at the mileage and time. Again, really didn't use the time, just used the mileage.
Now you can see from here, this is where we put the address into Google, apparently Google Maps, and you see the different routes that she could have taken. And you see on the right, it says typically 7 minutes, typically 6 minutes, typically 7 minutes. So this 6 to 7 minutes is actually Google's estimated time that it would take Karen Read to drive from 34 Fairview to One Meadows. Now remember, if she left at 12:32 and it's at least 6 minutes, well then she should not have connected to John's Wi-Fi at One Meadows until 12:38. Right, the earliest, that's 6 minutes. And that's what you see directly right here. It's on the screen. But then later, much later, we actually hear them go over this this data point itself. So listen to what happens here.
And you mentioned you measured or you ran information about distances between different routes,
Correct.
specifically regarding Fairview to Meadows, the first box. Do you see that?
Okay, so I see this is like a few hours later. Okay, you see how much I have to fast forward. This is a few hours later in the testimony. And then he comes back to this screen where he's talking about the drive from 34 Fairview to 1 Meadows, and you don't see anymore the Google Maps. You don't see that with the estimated time anymore. Now he's just going to concentrate on the actual miles that it takes to drive from 34 Fairview to 1 Meadows. And obviously also Dr. Welcher did acknowledge back in the beginning of trial when we just played it before that estimation is not taking into account any weather conditions or, by the way, someone who's drunk. But anyway, listen to how the questioning goes now.
I do.
There are 3 different mileage numbers.
Yes.
And then there's streets to the left. Can you explain what's set out in that box?
Sure. It's basically 3 different routes you can go: Sherman Street, Pleasant Street, Washington, and Sherman Street.
When you considered the shortest route, 2.3 miles on Sherman Street, did you attempt to determine how long it would take to travel 2.3 miles, how fast the car would have to be moving or how slowly it would have to be moving to travel 2.3 miles in 4 minutes and 15 seconds?
Yes.
And what did you determine?
So to go 2.3 miles in 4 minutes and 15 seconds, you would need an average speed of 32.47 miles an hour.
Now that doesn't sound so crazy. All she has to go is 32 miles per hour in order to make it back to 1 Meadows in 4 minutes. That sounds pretty reasonable. Now continue.
What if you took the longest route, 2.8 miles, and you considered 2.8 miles in 4 minutes and 15 seconds? Did you make a determination?
I did.
Could you share that with the jury?
It's 39.5 miles per hour.
Is that what the average speed of the Lexus would need to be to travel that distance in that
Correct.
time?
So she would just have to go about 40 miles per hour, which is not crazy. Not like she's flying, going 60 or 80 in order to get back in that time. That sounds pretty reasonable. But of course, Google also understands that, right? And Google put in that it's an estimated time is about 6 or 7 minutes. So again, it's a point that the defense can still definitely argue that although if you just look at the miles and maybe driving straight on a dry day without any lights or stop signs or anything like that, maybe she can actually make it in 4 minutes and whatever it is, 12 seconds. But as we saw from Google, and that's not accounting for the weather conditions and someone who's driving drunk, it should take about 6 to 7 minutes. So, okay, this is going to be a point of contention between the prosecution, whether she actually did that, and the defense saying it's not reasonable that she actually was able to make it in that amount of time. Then moving on, he spoke about the difference between, remember, there's 2 trigger events here. As you get very important, there's 2 different trigger events that night. And remember, the trigger events they're recorded by the time that you put on the car. So she presses the start button, and then from that time, there's 2 events that are recorded, 2 triggers that are recorded in the text stream and the Lexus data. Okay, so the first one, as we all already got familiar with, is the 3-point turn. That they refer to as 1162-1. 1162-1 is a 3-point turn. And then the question is, how much longer after that was the next trigger event, which was 1162-2. And that's when the Commonwealth alleges that this collision occurred. So you'll remember from the opening statement that, according to Hank Brennan, it was 7 minutes later. That's what he said in his opening statement. And let's see what Dr. Welcher says about how long it was between the 2 events.
Sure.
Dr. Welcher, did you determine how long after the first trigger, that 3-point turn, that this second trigger occurred?
Yes. 3-point turn occurred about 8 minutes after.
You said the 3-point turn occurred
I'm sorry,
after-
this event, I misspoke. 11.2 occurred about 8 minutes after.
after the 3-point turn.
Correct.
Thank you.
So Dr. Welcher is saying that it actually occurred 8 minutes later. So, you could be arguing that, what's 1 minute anyway? Okay, everybody messes up a minute. But again, remember that this timeline is very important to this case. I mean, seconds matter in this timeline. So when you're going to mess something up, you really can't mess up a full minute. Okay, so anyway, maybe I'm just being too particular with that. So you got Dr. Welcher saying it's about 8 minutes later. That was part of his testimony. And then he talks about the trigger event of 1162, which is the subject of everyone's interest right now. What happened, according to the data in her car, what happened at that trigger event, 1162. Now listen carefully, because I thought that this was a little confusing in the beginning. Maybe it won't be confusing to you, but I'll break it down for you. But listen to how the testimony comes out. I think it may have been confusing, and maybe even confusing to the jury.
And seconds gives you feet. That's how far you went. So you get.
So we're talking about how far when she threw into the reverse. Now, if you can see on the screen, it says ones. And again, if you're listening to the podcast, you can't see this. But if you see on the screen, what they're showing now is that the ones represent when it's in drive, 0 neutral, and 2 is in reverse. Now, what he's going to be talking about is how far she went. How many feet did she go, or did this car go at this trigger event, 1162, in reverse? How many feet did it go? So let's see if you can catch it, and I'll tell you what the real answer is after.
How far you went in each interval, then you get the total distance traveled. And so this is relative to the start. So 0 is the start. The vehicle goes forward about 34 feet. Then you see it basically stops in this area here, then begins to back up and ends up backing a total of 53 back from where it originally started. So if you add 53 to 34, you get 87. So the total motion, 34 forward, 53 back. The Lexus moved 87 feet total.
Dr. Welcher, when you say the Lexus moved 83 feet total, is that according to the data, or is that the entirety of the movement of that Lexus?
No, that's just from when the data starts to when the data ends.
So you see, he's talking about the car moved forward 34 feet and then backwards 53 feet. So you can think that he's talking, okay, so it went forward 34 feet and then backwards 53 feet. Now we know that Hank Brennan mentioned in the opening statement that the car went back at least 70 feet. That's what he said in the opening statement. So now you're listening to the expert, and the expert says, well, it went forward 34 feet and then went back 53 feet. But really, what he's really testifying about is that it went 53 feet back from the starting point, which means it went 34 feet forward, then went 34 feet backwards, plus another 53 feet, which is 87 feet. Now, if it went 87 feet backwards, then you may be wondering, well, then why didn't Brennan in the opening statement say the car went back at least 80 feet or 85 feet? Why did he cut it off at 70 feet? So your answer to that question is going to be something that I don't know. It's because I don't know why he said that. But that was just another thing that was just sticking out of my head. And again, they keep going through this over and over, that 34 feet frontwards, 53 feet backwards, and you're supposed to figure out what that means is 87 feet in total. 34 forward is just she has to go again 34 feet backwards, and then an additional 53 feet backwards. Anyway, so I thought it was a little confusing, and maybe the jury is confused. Who knows? Okay. He also testified that at this time, at this event, 1162-2, she was pushing on the gas, and again, this is their testimony that she was driving, obviously, so that she was pushing on the gas at a 74% throttle. That's pushing the gas pretty hard, and there was no brake application at all. And then the extent of this event lasts, and the last data point is that she was going 23 miles per hour in reverse, which means that according to the data, she went 87 feet backwards, but then would presumably continue going backwards. Presumably she would continue going backwards because she didn't hit the brake yet, and she's going 23 miles per hour backwards. So that means that she's going more, probably at least 90 feet backwards. Now, where exactly is she ending up now? And where exactly is Ryan Higgins' Jeep at this point? So that, again, the answer to that question is a little bit unknown at this point. And he said because it only records after that 1162 event, when it goes into reverse, it only records another 10 seconds. So you can't really see what's going on after. Anyway, fine. So then continuing on, he gets into another opinion here. And this is the important part, and really gets to one of the arguments that the defense is making in this case, which I never really bought. So hook, line, and sinker, didn't really make much sense to me, but he's really going to debunk the idea that this taillight was broken when Karen Read backed up into the Chevy Traverse at 5 o'clock in the morning when she was leaving One Meadows to go to Jennifer McCabe's house. Right. So we all remember that video of where she kind of nudges into the Chevy Traverse, and he put a whole interesting reconstruction together to show how it could never have caused the broken taillight that we're seeing in this case. So take a look at what he does here. or you can listen if you're on the podcast.
Damage to his vehicle. We then map that data onto Miss Reed's vehicle to look at where that height is. So you can see the only contact marks are down at the bumper level. I mentioned how that bumper sticks out. This is exactly where you'd expect it. So the only evidence of contact is nowhere near the upper taillight.
So he's just saying that the point of contact, and again, after he does this whole cool reconstruction, he shows that the point of contact between Karen Read's Lexus and John O'Keefe's Chevy Traverse that morning would have been much lower than where her taillight is, where the upper taillight is. Actually, the lower taillight, we're going to see the lower taillight actually did make some contact with the Chevy Traverse, but not the upper taillight. And he shows pretty clearly this in the reconstruction that he's doing here. Pretty cool stuff.
I emphasize the word upper taillight because it is right in line with the lower taillight, but yet the lower taillight also was not broken. So again, 25 and a half, that's 24 right here, 25 and a half, that's 24 right here, 25, 25 and a half. That's right where that scuff mark was.
And you can see where he's putting his mouse right there. It's on the picture on the left. If you can see this, there's a little scuff mark all the way in the bottom of her Lexus, which is nowhere near where her taillight was broken. So there's a little small taillight on the bottom of her Lexus, which you see a little scuff there, but he's going to say that he didn't find any broken glass there at all.
It's also right again, the level at the top of that light. This light is not broken. I've looked at the front of it. I've looked at the back of it. I've looked all around it. It's not broken, and it sticks out further in the light above it.
So very clear testimony from Dr. Welcher, debunking this whole idea that she cracked her taillight when she was backing up into John O'Keefe's Chevy Traverse. So that was pretty cool stuff, and I think it's pretty believable. So that was probably the best part, I think, of Dr. Welcher's testimony today, his reconstruction. I think it did a good job in showing that that's not actually what happened. Now, again, I don't know what the ARC experts are going to say, if they're going to try to explain how this could have happened, but I think that this was pretty credible. Now, moving on, he also said that the speed at which she was going backwards when she hit the Traverse was less than a mile per hour. It's like 0.7 miles per hour. So it was very, 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 very low impact. And again, he said very clearly, beyond a reasonable degree of engineering certainty, that this interaction between Karen Read's Lexus and John O'Keefe's Chevy Traverse would have never caused any crack in the taillight that is at issue. Okay. Then he moved on to the most important part. Okay, now this is the most important part of the case, hands down, no questions asked. This is where he has to really hit a home run. Okay, so this is what we're all waiting for. This next part, what I'm going to show you, this is literally what we're all waiting for, because remember, it all comes down to, did this collision happen with John O'Keefe? Even if this collision did not happen with the Chevy Traverse, and we have no idea how this broken taillight got anywhere, but the Commonwealth still has to prove that this interaction with John O'Keefe happened. So they have to be able to run this reconstruction to show how she backed up at 34 Fairview, went 23 miles per hour, and hit John O'Keefe, which caused the specific injuries on his arm, at least his arm. And there's also some other injuries. So this is what he did for that reconstruction. Take a look. If you can see this, hopefully you can. Just give me 1 second to get there. And here we go.
Could you go back to the beginning when you were explaining this so we can go through it?
So this is the dynamic test 2.
Now, in case you can't see this because you're on the podcast, he's dressed literally in John O'Keefe's clothing. See, he got a hat that John O'Keefe was wearing. He got the same exact shirt, same exact jeans, same exact sneakers, and he's about the same height and weight of John O'Keefe. So he's plugging himself into the equation as though he is John O'Keefe. And if you can see, and if you can't see this, he's standing right behind the Lexus. And now someone's going to back the Lexus into him.
So again, this is the view from behind. Just to avoid the confusion, I will start it here.
Now, as you see also, he kind of put this funny looking blue paint on the taillight, and his hand is standing about comfortable where he'd be by his waist, like holding a cup. and he's standing behind the Lexus, which has this blue paint on it. And the blue paint is going to get on his arm as it backs up into him.
What speed is the car traveling?
You can see it. About 2 miles an hour.
Excuse me, Your Honor, that is the objection that we spoke about.
Oh, okay. All right, so that's noted, Mr. Lexi.
So similar to the other test, this is the post.
So as you can see, if you can see this, you can see that the blue paint got on his arm, and it's very similar to the area where John O'Keefe's injuries are. So this is the reconstruction that he ran to show that those injuries could have resulted in the Lexus backing up into him.
Post-contact image of the transfers onto my arm.
So that was the extent of the reconstruction. That was it. A car going, this Lexus going, this exemplar Lexus, going 2 miles per hour backwards, hitting into his arm, which he's standing out there, and then putting this blue paint on his arm. And that was it. Now, what stuck out to me was that we saw how cool his reconstruction could be. As he showed us with the Chevy Traverse, as he showed us with the Karen Read backing into the Chevy Traverse, he had all this cool stuff going on with the reconstruction. And then when it comes to trying to reconstruct this accident, which is what he needs to do, this is how he needs to convince the jury that this interaction actually happened. He shows the Lexus going 2 miles per hour backwards and then into him. So there's no other, that's it. That's the extent of the reconstruction. And I think we're all kind of waiting for like this really cool reconstruction. You have a dummy and you have this car going backwards 20 miles per hour, or maybe 13 miles per hour, or 15 miles per hour, and smashing into this dummy and then showing the pattern of abrasions which occurred on his arm. All he's showing is that the car could hit him at that level. He's not showing at all how the pattern abrasions could have resulted from that interaction. He's not showing how the taillight could have shattered that way and how the damage to the vehicle could have happened that way. So I think that it was severely lacking. I mean, comparing it with his other reconstruction in this case, which was really cool stuff. And here, this is like the best he's got. He just has a Lexus back up into him and have that on video, and he gets this blue paint over his arm, which is around the area where John O'Keefe was hurt or damaged or injured. So, I mean, I think we're all kind of just waiting for a more elaborate explanation, a much more elaborate simulation and reconstruction of how this could have happened. And it just didn't happen today. That's not what he testified to. That was the extent of the reconstruction. So he also said that he believes that there's a scuff at the hip level where the jeans could have hit into the car, and the right knee abrasion he thinks was from the bumper, and also the laceration on the right eyelid. Remember this laceration on the right eyelid? Even the neurosurgeon, the brain surgeon who was called into this case, Dr. Isaac Wolf, he said that he doesn't know this whole ecchymosis and this whole falling backwards wouldn't have caused the laceration on his right eyelid. So how did that happen? And Dr. Welcher's theory is that the top part of the Lexus, which is very close to his height, it's around 73, 71 inches, around that height. That's what hit into John O'Keefe's right upper eyelid. And again, there was no reconstruction for that. He just kind of showed his height near that top of the Lexus. And he said, I guess that's the theory here. But there was no video. There's no reconstruction with a dummy showing how this all interacts with each other and how all this damage is created and injuries sustained. So I think it was very lacking. I think we were all expecting a lot more from Dr. Welcher in terms of the specific reconstruction to show how the damage to the vehicle and the injuries to John O'Keefe are consistent with one another. Also, remember that the body had to be propelled at least 7 feet. He said 7 feet. Seems to be like there was more like 10 feet away from the curb. How did that happen? He didn't explain how that happened at all. It just shows that, look, I even bounced around off of the Lexus. I even spun around the Lexus a little bit. Okay, but how did they propel the body? Show us how that happened. And he didn't. Now, again, maybe we're in the middle of his direct examination, but it seems like at the end of the direct examination, Hank Brennan was just asking for his ultimate conclusions on the case, and that's it. He was trying to move on. and be done with him and move and let cross-examination begin. So again, I think, a lot of it is still lacking. And I think a lot of jurors can be still thinking, how did this all happen? I understand that it's possible for someone that's 6 feet to get hit by the back of a car. I understand that part. And maybe his arm could get hit by that. But how do you only sustain abrasions, superficial abrasions, no bruising, no contusions, no fractures, no ligament and tendon issues or injuries? How did that all happen? So the jury can still be thinking that. And it wasn't clear today at all. He also spoke about today that somebody called the hat line analysis, the hat brim analysis, which is where the end of the hat, when you're wearing a hat in the back, that's what they call the hat or line or hat line analysis, that over there, it's most consistent with damage, with injuries sustained in the back of the head, which is what happened to John O'Keefe in this case, to be from a fall. And then he showed how he dropped the dummy on his head, and it's consistent. And that was also consistent with someone being dropped on his head and probably hurting himself. But again, not showing exactly how this specific injury would occur, and the pattern of what happened to the back of his head. So he didn't show anything like that. Okay, so then he tried to get to the ultimate conclusion here. Okay, he was trying to get to the final conclusions, and that is when some more interesting things happened in court. So let's go all the way to the end of what happened today, which is why you always have to watch to the end, because there's always some interesting things happening at the end. And this is where it seems like Hank Brennan's trying to wrap up the case and just ask him what his ultimate conclusions are on the case that Karen Read or her Lexus banged into John O'Keefe. And we'll see what happens after some argument, some objections, jury gets dismissed, and then there's some more oral argument. So here we go.
Interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
So I'm going to strike that. I'm going to see counsel's just.
Okay, so you heard the last two questions. Is that what happened? Is it consistent with this collision, essentially this collision happening? And he said, yes. And in my opinion, that is what happened. Not just that it's consistent, but that is what happened in this case. Okay, so that prompted an objection by Robert Alessi. They had a sidebar, and then we had some oral argument on the record about that objection. So Judge Cannoni dismissed the jury, told Dr. Welch he has to come back tomorrow anyway. So we're going to start tomorrow at 10 a.m., by the way, just a reminder again. And this is where they started some argument about whether an expert is allowed to testify that a collision happened. So listen to how Robert Alessi argues it, and then we'll listen to Hank Brennan's response.
You all hear from within the next 5 minutes. Go ahead, Mr. Alessi.
Thank you, Your Honor. The point number one is the question of whether.
And I'm sorry about the audio. It's just he's not standing so close to a microphone. It's nothing that I can do.
Based on a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain death, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact.
So he's bringing an analogy of, let's say the issue is whether somebody stabbed somebody else. Let's say that was the issue in the case. Can an expert get on the stand and say, in my opinion, yes, the defendant stabbed the victim? Is he allowed to do that or not? So Robert Alessi is saying, no, you're not allowed to do that. A witness is not allowed to give an opinion about, it's called the ultimate issue. The ultimate issue is the issue that the jury has to decide. So you cannot ask a witness to give his opinion about whether this person committed the crime.
That analogous situation, the question of whether there was a collision is the ultimate question for the jury.
So he's saying that here, what is the question for the jury? The ultimate question for the jury is whether a collision happened. If a collision happened, Karen Read is guilty of something, right? So that's what his argument is, that if a collision happened, that means you're going into the province of a jury, And you're saying that this expert is being allowed to testify that a collision happened. And if a collision happened, then she is guilty of something, maybe involuntary manslaughter, maybe second-degree murder, but she is going to be guilty of something. So he's saying that is not permissible. You're not allowed to ask that of a witness. Now listen to more what his argument is.
That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle?
So what Alessi is saying here is that what you are allowed to ask is you're allowed to ask if the damage to the vehicle is consistent with a pedestrian strike, and are the injuries suffered by the pedestrian consistent with a vehicle strike? That you're allowed to ask. You're not asking if there actually was a collision or not, as he tried to testify, Dr. Welcher, that there was a collision. No, you're just saying that the damage to the vehicle and the injuries to John O'Keefe are consistent with one another. That's okay.
Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Lisi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that when his expert takes a stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to.
Now, I just want to point out something about Hank Brennan's argument here. The fact that the attorneys argue to the jury about what is happening in the case, you're not testifying as a lawyer. It's very, very different when you have a witness on the stand. A witness on the stand cannot give testimony about an ultimate issue. Lawyers all the time tell the jury that they should find their client not guilty because they never committed a crime. Does that mean that they're invading the province of the jury? No, you're allowed to do that as a lawyer because the judge says very clearly that the lawyer's comments and statements are not evidence. But when it comes to evidence, then evidence you're not allowed to give an opinion on an ultimate issue. So his first argument here is just not a good one. Okay, the fact that they said it in their opening statement is completely fine and doesn't invade the province of a jury. The whole idea of invading the province of a jury is only when it comes to a witness.
Entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road.
And again, the argument here that all the evidence supports that there's a collision is an inference that the jury can make if they so choose. That has nothing to do with the actual argument of whether a witness is allowed to make that inference himself. All the witness should be allowed to say is that the damage to the vehicle, again, and the injuries to John O'Keefe are consistent with one another. That's fine. And if you want to argue, Hank Brennan, that the inference in the case is clear, that there was a collision, fine, argue that to the jury. You're allowed to argue that. You're a lawyer. And the jury can make that inference if they so choose. It doesn't really go back to the actual issue that they're arguing about. And then after he said that the defense did not cite any sort of citation to this and any authority, and as you know it from watching this channel, that you got to cite some authority if you want the judge to side with your position. Afterwards, they did cite a case actually. So unless he did pull out a case, I'm not sure who pulled it up really quickly, but they did eventually pull out some sort of cite case which says that you're not allowed to do that. So Judge Cannoni, like very often, took it under advisement, and she's going to tell everybody what her ruling is going to be tomorrow. So that's going to be tomorrow at 10 a.m. So join us back here, right here, Brother Counsel Studios, 10 a.m. for the continued live stream. Day 22, you don't want to miss it. It's a cross-examination of Judd Welcher. Maybe they're going to finish even with Welcher tomorrow. Who knows? Not sure. And then we're going to probably hear maybe the Commonwealth arrest. And then we're going to have a directed verdict motion by the defense, which is going to be denied. And then the defense is going to start with their case. So we may be getting a little ahead of ourselves, but definitely the cross-examination of Judd Welcher is going to happen tomorrow. And join us here for that tomorrow, 10 a.m. That's going to be it for today. That is day 21. Tomorrow's day 22. If you haven't yet, please subscribe and like, and we will see you next time.